What's up, Crim Heist? Welcome to another criminology educational video. And for today, we will be discussing institutional correction. So before anything else, let me introduce myself. I am Sean Francis Sandiego, also known as the Professor. So in this video discussion, we'll be focusing ourselves to the concept of punishment and the school of thoughts in correction. So, what are the contemporary forms of punishment? So, first is imprisonment, the most common form of punishment. So, lagi nating tatandaan na ang most common form or kadalasang parusa na ibinibigay sa mga taong gumagawa ng krimen ay imprisonment o ito yung tinatawag natin na pagkakakulong. So putting offenders in prison for the purpose of protecting the public and at the same time rehabilitating by requiring the latter to undergo institutional treatment program. So ibig sabihin daw, ang pagpapakulong or ang pagkukulong sa isang tao na gumawa ng krimen ay ito ay para sa purpose or kadahilanan na protektahan ang mga members ng community or members of the society para mapigilan din or ma-prevent yung tao na yon na gumawa ng krimen or mag-cause ng harm sa society. Also, one of the purpose of conducting imprisonment or applying imprisonment for those person who are convicted by final judgment is to rehabilitate them. So the very reason kung bakit kailangan silang ikulong is to rehabilitate them or i-reform sila. Tanggalin yung mga criminal behavior or meron silang criminal behavior, kailangan yung tanggalin at sila i-transform into a law-abiding, productive citizen. Second is payment of fine. This is common to violators of minor offense. However, there are crimes where fines are imposed with imprisonment. So ito namang payment of fine, ito yung pagbabayad o yung tinatawag natin na civil liability or yung daños perjuicio. Usually ito ay ginagawa lamang sa mga minor offenses. Ngunit meron din namang mga pangyayari kung saan yung krimen ay may parusa na pagkakakulong at meron ding payment of fine. Next is parole. Parole is under the non-institutional correction. It is defined as a procedure by which the prisoners are selected for release on basis of individual response to the progress within the correctional institution and service by which they are provided the necessary controls and guidance as they serve the remainder of their sentence within the free community. So, ibig sabihin lang dito sa parole, yung parolee ay na-reach na or siya ay qualified because na-reach na ang minimum indeterminate sentence. And therefore, the remainder of his or her sentence will be served in the community. So next is conditional pardon. It is an executive clemency to be exercised by the President. It is a mercy given but with conditions upon the release of the grantee. So alam naman natin na ang pardon ay merong dalawang kinds yan, the absolute and conditional pardon. So para mas mapadali, pag absolute pardon without any conditions, you are a free man. Pero pag conditional pardon from the word itself, conditional, ibig sabihin may mga kondisyones na kailangan kang sundin upang ma-retain yung iyong pardon. So, ibig sabihin, ikaw ay igagrant ng pardon but with conditions. Next is probation. It is a procedure under which an accused is found guilty of a crime, is released by the court with conditions and subject to the supervision of a probation officer. So, para mas madali, i-differentiate natin si probation kay parole. Si parole, kailangan mag-serve ka muna ng minimum indeterminate sentence. So, the keyword there is merong jail time. Dito kay probation, wala tong jail time. Right after na ikaw ay mababaan ng desisyon, ikaw ay magagrant ng probation if you applied for probation. So, ano ba ang qualification? So, para mas mapadali tayo, the qualification or the main qualification for you to be qualified to apply for probation is of course yung imprisonment na punishable na offense na ginawa mo or ang parusang binigay sa'yo is not exceeding 6 years. Okay? Not exceeding 6 years. Next is death penalty. Sentencing a convicted person to death, especially to those who convicted of heinous crime. Ito yung pagpatay. So, ang death penalty, hindi na ito ginagawa sa Pilipinas. Next is corporal punishment. Some countries are still imposing physical torture as punishment. But in our country, here in the Philippines, we are no longer using physical torture as a form of punishment because of the constitutional prohibition of such imposition. Corporal punishment in our country is given through life imprisonment. sapagkat ang konstitusyon natin ay pinoprotektahan ang karapatang pantao ng isang akusado at ng kriminal. So, ang justice system natin is nakafocus talaga siya, or ating batas ay nakafocus sa pagpoprotekta ng mga kriminal or the rights of the criminals. Therefore, they are free from any physical torture. It may either be physical or emotional or the infliction of physical pain. So, hindi na yan po pwede sa ngayon. Next is banishment, otherwise known as transportation. This is carried out by sending or putting away an offender either by a prohibition against coming into a specified territory or a prohibition against going outside a specified territory, such as island to where the offender has been removed. Isa lang ang keyword dito sa banishment, ito yung pagpapatapon. Ipinapatapon mo yung isang kriminal or yung isang convicted offender malayo sa lugar mo. Okay, usually ito ay ginagawa, itinatapon sila sa mga islands or any other territories basta outside ng iyong jurisdiction. Next is community service. Like payment of fines, this is commonly imposed to those simple infraction of the laws. So what are the justification of punishment? Ano daw ba yung justification bakit kailangan nating magbigay ng parusa? Unang-una ay retribution. It involves the payment of a debt to both the victim and the society, and thus atonement for a person's offense. It literally means paying back the offender for what he or she has done. Punishment involves a setting of scores for both society and the victim. Victims are entitled to get even or is short personal vengeance. So, ibig sabihin, retribution, ito yung vengeance or ito yung paghihiganti. Personal vengeance. Ano naman ang expiation or atonement? Ito yung tinatawag natin na group vengeance. Next is deterrence or exemplarity. It is the discouragement or prevention of crimes similar to one for which an offender is being sentenced. It is future-oriented in that it seeks to prevent crimes from occurring. Two forms of deterrence can be identified. So pag sinabi nating deterrence or exemplarity, it gives example or dinedeter or tinatanggalan natin na kumbaga hindi natin hinihikayat. So nakaka-discourage, dinidiscourage natin yung mga tao. Dalawa kasi yan double blade yan. Pag sinabi nating specific deterrence, it is the deterrence of the individual being punished from committing additional crimes. Ito namang general deterrence, it is to serve as an example to others. Para mas mapadali tayo, pag sinabi nating specific deterrence, ito yung dinedeter natin yung kriminal sa paggawa ng panibagong krimen. It is deterring them or preventing them to re-engage into criminal activity. Pag sinabi nating general deterrence, ito yung deterrence to the community or to the other people or to the members of the society for them not to engage to criminal activity. Next is protection or social defense, shown by its inflexible severity to recidivists and habitual delinquents. So, sinasabi naman daw na kaya tayo nagbibigay ng parusa as a way of protecting the members of the society. Next is reformation. The goal of this is to change the criminal lifestyle into law-abiding ones. It is accomplished when an offender's criminal patterns of thought and behavior have been replaced by allegiance to society's values. It focuses on medical and psychological treatments and on social skills training, all designed to correct the problem that led to the individual to crime. Sinasabi lang dito sa reformation, nire-reform or binabago natin yung masamang nakaugalian ng isang kriminal. Binabago o tinatanggal yung criminal behavior, the delinquent behavior na meron yung isang tao na nagtulak sa kanya or naging dahilan para siya ay gumawa ng krimen. Next is theories of justifying imposition of penalty. First is prevention theory. Ito yung sinasabi natin na pinaprevent nga ang re-engagement or engagement to criminal activities. Self-defense theory, the state has the right to punish the criminal as a measure of self-defense, as to protect the society from the threat and wrong inflicted by the criminal. Reformation theory, ito naman yung nire-rehabilitate or kinokorek mo, tinatanggal mo yung criminal behavior na meron ng isang convicted offender. Exemplary theory, ito yung deterrence na sinasabi natin, to set as an example, to serve as an example, and to deter others from committing crimes. As to justice theory, the crime must be punished by the state as an act of retributive justice, a vindication of absolute right and moral law violated by the criminal. Next is protection or social defense. Next is the constitutional provisions for the imposition of punishment. So ibig sabihin ito daw yung constitutional basis in providing or in inflicting punishment. Nandiyan ang Section 1, Article 3 of the 1987 Constitution, the main provision in prescribing limitations for punishment. Sinasabi rito that no person shall be deprived of life, liberty, or property without the due process of law, nor shall be denied the equal protection of the laws. So considering that by imposition of punishment, a person may be deprived of life, liberty, or property, the Constitution requires the observance of two constitutional guarantees, the due process of law and the equal protection of the law. Ano yung due process of law? Ito yung karapatan ng isang tao upang dinigin ang kanyang kaso, upang bigyan siya ng karapatang protektahan ng kanyang sarili. Ang equal protection of the laws naman, no matter what your social status is, mayaman, mahirap, maputi, maitim, matalino o bobo, sa mata ng batas, lahat ay pantay-pantay. What are the judicial conditions of penalty? So first, it must be productivity of suffering without however affecting the integrity of the human personality. Second, must be commensurate with the offense. Kailangan pantay yung degree ng krimen na ginawa mo doon sa punishment na ibibigay sa'yo. So kailangan kung malala yung krimen na ginawa mo, kailangan malalang punishment din yung ibigay sa'yo. Next is must be personal. So wala ditong substitution. So no one should be punished for the crime of another. Fourth, must be legal. It is the consequence of a judgment according to the law. Kailangan daw yung penalty or parusa na ibibigay sa'yo ay nararapat at ito ay galing sa batas. Next is must be certain. No one escape its effect. Must be equal to all. So, for example, si Juan at si Pedro parehas na ginawa yung krimen ng murder. And same degree, same nature, same element, same circumstances, kailangan parehas sila ng parusang ibibigay o ipapataw. Next is must be correctional. Kailangan lahat ng punishment ay for the main purpose or for achieving the objective of correcting or rehabilitating the offender. Other consequences of punishment. So first is punishment through imprisonment often isolates the criminal, causing in him a stigma and develops in his person a strong resentment of authority. Sinasabi lang dito na dahil nga sa pagpaparusa or sa pagpapakulong, siya ay na-isolate. And therefore, it creates a stigma or it creates a dilemma or an anxiety to the criminal. Second, it may develop cautions on part of the criminals for their illegal activities to avoid punishment to be imposed by the government if caught. So, sinasabi dito, nagiging cautious daw sila upang hindi na uli mag-re-engage sa criminality. Next is constructive efforts of the government may not be appreciated, causing of lack of respect for the law, lack of patriotism, and loss of self-respect. Other citizens may idolize the criminals, thus giving an offender higher status as alpha male in his community. Next is effects of punishment. It is recognized that some form of punishment can be effective when applied in the right amounts and at the right time. But when the ideology of punishment is applied in a correctional institution, the result is usually negative for both the punished and the punisher. So correctional personnel tend to watch for minor rule infringements or non-conformism so that punishment can be administered. And they overlook the positive actions by offenders. Often the rules that are prepared for a punishment-oriented environment surround the offender with a wall of do not, leaving almost no leeway to do anything. So, ibig sabihin, sinasabi dito na yung mga correctional personnel daw or mga jail officers, sila ay laging nakatingin lang sa mga maliliit na bagay na ginagawa ng mga nakakulong doon upang sila ay makapagbigay ng parusa. Sinasabi rin dito na dahil sila ay nakafocus lang sa mga minor rules infringements or minor rules violation, sila ay na-overlook nila yung main reason kung bakit ito ay nakakulong upang ito ay bigyan ng rehabilitation. As evidenced by a high crime rate, it seems that punishment is ineffective to stop criminal activities, and in the process, punishment is enforced more severely as a means to control criminal behavior, which in turn makes the offender becomes more sophisticated in perpetrating his criminal activities with a belief that makes him or her less likely to be detected. Sinasabi lang dito na nagiging inefficient daw ang goal ng punishment or ng penalty, it is because mataas pa rin ang crime rate. And therefore, dahil ito ay nakafocus ang mga correctional officers natin in controlling the criminal behavior and not rehabilitating or not reforming the person. With the continued application of coercive methods, the offender becomes hardened by the punishment, and the administrator learns to dole it out automatically, as their only means of control. Both parties are degraded in the process. However, there are other factors that contribute to make punishment at least effective means of reducing crime. Over severity of punishment may arouse public sympathy for the offender. Those persons most likely to be imprisoned are already accustomed to experience deprivation and frustration of goals routinely in daily life. So, ibig sabihin, wala na sa kanila yung punishment na ibibigay sapagkat sa kanilang pang-araw-araw na buhay, sila ay nakakaranas na ng mga frustrations and deprivations. It is impossible to fashion a practical legal slide rule which will determine exact degrees of retribution appropriate for the list of crimes ranging from simple theft to murder. The simple application of naked coercion does not guarantee that the subject of its force will alter their behavior to conform to new legal norms or to improve their conformity with norms previously violated. The possibility of deterrence varies with the chances of keeping the particular type of crime secret and consequently of avoiding social reprobation. Exemptions from punishment. So, not everyone found violated by penal laws will be subjected to punishment. So, galing sa Article 12 of the Revised Penal Code as amended, the following are enumerated circumstances which exempt a person from criminal liability. So, ito yung exempting circumstances. Imbecile or insane person unless the insane person has acted during lucid interval. Imbecile ito yung isip bata, insane ito yung baliw. So, magiging liable lang ang mga baliw if siya ay gumawa ng krimen during the lucid interval. Itong lucid interval, ito yung time kung saan siya ay nasa matinong pag-iisip. A minor under 15 years of age, a minor over 15 years of age but under 18 unless he acted with discernment. Pag sinabi natin discernment, ito yung he or she can decide or process what is right or wrong, of course, and to appreciate the possible consequences of his actions. And pag siya ay gumamit ng discernment or siya ay may ginawa, acted with discernment, siya ay magiging liable. Any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. Ito daw yung isang tao na to ay gumagawa lang ng tama or nasa legal lang siya, ngunit dahil may isang aksidenteng nangyari, it causes an injury or harm to the person. But kailangan dito nating malaman na ito ay without fault or intention of causing it. Any person who acts under the compulsion of an irresistible force, ito yung pinilit lang siya, he or she was coerced na gawin yung bagay na yon against his or her will. Number 6, any person who acts under the impulse of uncontrollable fear of an equal or greater injury. Ito rin yung type ng coercion kung saan pinipilit siya at pag ito ay hindi niya ginawa, siya ay papatayin. So, kaya siya ay napilitang gawin yung isang bagay na yon. Any person who fails to perform an act required by law when prevented by some lawful or insuperable cause. So there are also persons exempt from the operation of our criminal law by virtue of the principles of public international law. Ito yung mga sovereigns and other heads of the states, ambassadors, ministers, plenipotentiary ministers, resident and charges the affairs. Now let's go to the school of thought in correction. So, nandyan, of course, the pre-classical theory. Sinasabi dito yung secular theory of punishment. The first person who attempted to explain crime is Aristotle, an Athenian philosopher. So, in his book entitled Nicomedean Ethics, he discussed the philosophy of corrective justice. According to him, punishment is a means of restoring the balance between the pleasure and pain, whereby the loss suffered by the victim is compensated by the suffering of the offender, hence restoring the balance between the injured and the transgressor. Sinasabi lang dito sa secular theory of punishment, kaya daw pinaparusahan yung taong gumawa ng krimen as a way of balancing the pleasure and pain. Nasaktan mo yung biktima, ikaw din ay dapat masaktan upang ma-restore yung balance. Okay? Next is Judean Christian theory. This theory adhered that punishment has a redemptive purpose of repelling sin advocated by the devil. This theory was its fullest development during the death of Christ in 30 AD. Next is the rise of canonical courts. In history, a system of trial and punishment was established in the 4th century AD. The rivalry existed between church and state in trying offense. In the early Christian era, the church forbade its adherents to resort to state court, and later in the medieval period, the power of state courts declined and the power of canonical courts was mainly reformatory in purpose. Dito sa rise of canonical courts, ito yung mga church courts na sinasabi natin. Next is individualization of punishment. The lawmakers and judges had the practical task of making and administering law, not only in the light of such theories of free will and responsibility, but also face to face with the indignation of the community at a particular offense. Abuse of judicial individualization. So the law gave judges wide discretion to impose additional penalties in view of the circumstances. This theory gave the judges tyrannical power, which led to abuses. Class discrimination in the administration of justice arose. Dito naman, binibigyan ng kapangyarihan, malayang kapangyarihan ng mga judges upang magbigay ng parusa na nararapat, naaayon, o kung ano yung sa tingin nila ay tama. At ito ay naging vulnerable or open to corruption and abuses. Next is classical school. Alam naman natin, pag tinawag natin yung salitang classical school, ito yung free will nating tinatawag. Sinasabi rito, it is a direct result of, it came about as a protest against the abuses of discretionary power of judges and influenced by the school of French philosopher and writer Rousseau and his writings contained in his book Social Contract. In 1764, Beccaria published an essay on crimes and punishment. So, dun sa essay niya, Beccaria outlined a utilitarian approach to punishment, suggesting that some punishment can never be justified because they are more evil than any good they might produce. The use of torture to obtain confessions falls into that category, said Beccaria. Dito sa classical school, dito na inabolish yung mga inhumane punishment. He also protested punishment for the insane, a common practice of the times, saying it could not do good, no good because insane people cannot accurately assess the consequences of their actions. Beccaria said that ex post facto laws or laws passed after the fact impose punishment unfairly since a person could not calculate the risk of acting before a law against a specific action was passed. Sinasabi rin dito sa ex post facto law, kailangan daw hindi parusahan yung isang tao kung yung bagay na ginawa naman niya yon at that time he committed the act. Wala pa namang batas na nagpo-prohibit para ito ay gawin. Beccaria proposed that punishment could be justified only if it was imposed to defend the social contract, the tactic allegiance that individuals owe their society, and the obligations of government to individuals. It is the social contract, said Beccaria, that gives society the right to punish its members. Sinabi rin dito that the punishment should be swift, since swift punishment offers the greatest deterrence. Beccaria's protest was directed against the following: arbitrary penalties given by the judges, uncertainty and obscurity of the laws. So, hindi daw certain or hindi daw distinct kung ano daw ang sinasaad ng batas. Defects in criminal procedures in admission of testimonies, secret accusations, of course, torture and incrimination of witnesses, long pending cases, and abuse of power by rich against the poor. Next is Neoclassical School. The principles of classical school remained intact, but the system of defined and variable punishment was modified. The judge was given discretion in certain crimes to vary punishment between maximum and minimum fixed by law. Significant contributions of Neoclassical School: exempting circumstances, reduction of punishment for partial freedom of the will, only partial punishment. Punishment mitigating for lack of full responsibility. It represents the reaction against the severity of this classical theory of equal punishment, irrespective of circumstances. Next is positive school. Defined individual responsibility and reflected an essentially non-putative reaction to crime and criminality. Since the criminal was held to be not responsible for his acts, he was not to be punished. The adherents of this school maintain that a crime, as any other act, is a natural phenomena. According to Rambroso, merong 3 great classes of criminals. Born criminals, ikaw ay merong kang atavistic stigmata, mukha kang hayop. Second is insane criminals. Ito yung mga idiots, imbecile, dementia, paralysis. Ito yung merong mga mentally disabled. Criminaloids not born with physical stigmata but who are of such mental makeup that they display antisocial conduct. Ito naman yung mga psychological defect and not physical. Published in 1878, The Theory of Imputability and Denial of Free Will. Ferry contributed to emphasis of social factors. Physical factors including geographical, climate, and temperature. Anthropological including psychological, and social including economic and political favors, as well as gender, education, and religion. Sinasabi lang dito sa kay Enrico Ferri is that hindi lang physical or sa katawan ng tao ang nagiging dahilan sa paggawa ng krimen. Bagkos, ang paggawa ng krimen ay maaring may contribution ang outside factors or external factors. Maaring nandyan yung kainitan ng araw or yung climate, maaring nandyan din yung kahirapan, nandyan din yung mga political favors, and the likes. According to him, crime can be understood only as it is studied by scientific methods. The criminal is not a free moral agent, but it is the product of circumstances. He traced the roots of criminal behavior to psychological equivalents to stigma called moral anomalies. Likewise, natural crimes are found in all societies, regardless of the views of lawmakers, and no civilized society can afford to disregard them. These are among the beliefs of Garoppolo regarding natural crimes and peculiarities. Peculiarities, ito yung particular characteristics that place offenders at risk of criminal behavior. Extreme criminals, these are execution for punishment. Impulsive criminal, imprison for punishment. Professional criminals, ito yung punishment is elimination, either by life imprisonment or banishment, or transportation to a penal colony overseas. Endemic criminals, controlled through changes in the law. Pag sinabi nating endemic criminals, dahil in yan sa lugar mo, kaya ito ay ginagawa. Okay? Endemic para bang pandemic. Nakakahawa. Lastly is modern clinical school. It studies the criminal rather than the crime. This school is interested primarily in the personality of the criminal himself in order to determine the conditioning circumstances that explain his criminality, and in order to determine the conditioning circumstances that explain his criminality, light upon the problem of how he should be handled. So dito sa modern clinical school, tinatrato na dapat daw ang intindihin ay yung factor inside, which is the criminal itself, and not understanding the crime. So, mas nakapokus siya sa criminal rather than the crime. So, that's it. Thank you very much, and I do hope that you learned a lot from this video discussion. If you love this video, please don't forget to like, comment, share, and subscribe to the professor, and hit the notification bell for you to be updated for my next upload. Thank you very much.